All rise.
Her Excellency President Carmona, Your Honors, Excellencies, distinguished guests. Today's ceremony will be opened with remarks by President Judge Silvia Fernandez de Gourmendi, followed by a musical intermezzo. After the musical intermezzo, we will hear the remarks by the distinguished guest speaker, President Anthony Carmona, after which the President of the International Criminal Court will officially open the ICC's Judicial Year 2018. Interpretation into English, French and Spanish is available. For the middle block, English interpretation is the floor. If you just switch on your headsets, it will work. English for the other blocks is channel 1, Français la chaîne 2, Spanish channel 3. I now invite the President of the International Criminal Court to take the floor.
Monsieur le Président du Trinité et Tobago, Monsieur le Président de l'Assemblée des États parties, Mesdames et Messieurs les juges représentant les tribunaux nationaux, régionaux et internationaux, chers collègues, Madame le procureur et Monsieur le procureur adjoint, Monsieur le greffier, Monsieur le président de l'Association du barreau, Monsieur le ministre de la Justice de la Libye, Madame la secrétaire générale du ministère des Affaires étrangères représentant l'État hôte, Excellences, distingués invités, je voudrais souhaiter chaleureusement la bienvenue à chacun d'entre vous à l'occasion de cette cérémonie d'ouverture de l'année judiciaire 2018. Nous organisons cette cérémonie pour la première fois à la Cour pénale internationale. En cela, nous suivons une tradition bien ancrée au sein de plusieurs tribunaux. Par cette cérémonie, nous mettons l'accent sur la nature judiciaire de notre institution, laquelle n'est guidée que par le texte qui la gouverne. Nous rappelons également notre engagement à exercer nos attributions en tout honneur et dévouement, en toute impartialité et en toute conscience. Par ailleurs, la cérémonie d'ouverture de l'année judiciaire nous donne l'occasion non seulement de favoriser une meilleure compréhension du travail de notre Cour, mais aussi de tisser des liens avec des juges d'autres tribunaux dans le but d'échanger des points de vue et des expériences dans l'exercice de nos fonctions respectives. Plus tôt aujourd'hui s'est tenu le premier séminaire judiciaire de la CPI qui a rassemblé près de 60 juges venant de plusieurs pays, de plusieurs tribunaux régionaux et internationaux, de même que de notre Cour. Les discussions que nous avons eues sur la complémentarité et la coopération entre les juridictions ont été stimulantes. Elles pavent la voie à des interactions fructueuses dans le futur. Je suis grandement reconnaissante aux nombreux présidents du tribunal et autres juges de haut rang qui ont entrepris parfois un long voyage pour se joindre à nous aujourd'hui. Leur présence honore notre institution et symbolise notre appartenance à un système de justice mondialisé et interconnecté. Nous avons beaucoup en commun, puisque nous travaillons tous à promouvoir la justice et l'état de droit. De plus, comme la CPI est une institution de dernier recours, tous les juges nationaux peuvent un jour avoir à intervenir pour le même genre de crimes qui relèvent de la compétence de la Cour et faire face aux mêmes défis que ceux de la Cour. En effet, il est attendu que les États prennent action et ils sont d'ailleurs encouragés en ce sens en vertu du principe de complémentarité du statut de Rome. L'avenir de l'État de droit réside dans le dialogue et la collaboration, pas dans l'isolement. Excellences, Mesdames et Messieurs, l'ouverture de l'année judiciaire marque également le début de l'année de célébration du 20e anniversaire du traité fondateur de la Cour, le Statut de Rome. Cette étape importante sera soulignée à l'occasion de plusieurs célébrations durant l'année. L'une des premières aura lieu le mois prochain à La Haye et sera organisée par la Coalition pour la Cour pénale internationale. Cette cérémonie s'impose de soi, puisque la société civile a joué un rôle très important dans la création de la Cour. J'ai moi-même eu le privilège de prendre part aux négociations du traité et d'être présente à Rome pour l'adoption du statut. Alors que mon mandat de juge et présidente de la Cour tire à sa fin, je suis heureuse de constater que la Cour a réalisé d'énormes progrès depuis sa création, il y a de cela 20 ans. La Cour a gagné en maturité et connaît un volume de travail judiciaire croissant. Elle joue désormais un rôle de premier plan dans le système de justice pénale internationale. Elle apporte une contribution importante au développement d'une exigence des responsabilités pour les crimes internationaux les plus graves. Cette exigence des responsabilités est aujourd'hui inscrite en bonne place à l'ordre du jour mondial. Il est désormais largement admis qu'il est obligatoire de mettre fin à l'impunité pour les crimes les plus graves qui touchent l'ensemble de la communauté internationale. L'émergence de ces principes comme normes de droit international a changé les paramètres de la quête de la paix. Le monde a désormais l'espoir que les auteurs des crimes les plus graves auront à répondre de leurs actes et la conviction qu'il s'agit d'une nécessité afin de parvenir à une paix durable. La question n'est plus de savoir si la justice sera appliquée, mais de savoir quand et de quelle manière elle le sera. Toutefois, malgré les nombreux progrès réalisés, il subsiste de vastes lacunes qui permettent à l'impunité de continuer à prospérer. Pour y remédier, il est indispensable de conjuguer les efforts de systèmes de justice internationaux, régionaux et nationaux. Une juridiction, quelle qu'elle soit, ne peut à elle seule faire face à de tels crimes qui impliquent des auteurs multiples et causent des milliers, voire des centaines de milliers de victimes. Il importe de souligner tout particulièrement que chaque État est responsable au premier chef de prévenir le génocide, les crimes contre l'humanité, les crimes de guerre et les crimes d'agression, de mener des enquêtes sur ces crimes et d'en poursuivre les auteurs. Les juridictions internationales et régionales peuvent agir en complément d'action des États, mais ne pourront jamais les remplacer. Une des retombées positives de cette complémentarité est qu'un nombre croissant d'États ont mis à jour leur législation afin d'être en mesure, au niveau national, de mener des enquêtes sur des crimes internationaux et d'en poursuivre les auteurs. D'autres États ont également introduit dans leurs appareils juridiques des services spécialisés pouvant faire face à de tels crimes. Ces nombreuses initiatives sont louables et elles sont aussi nécessaires à l'établissement d'un système de justice mondiale efficace. C'est pourquoi il est aussi important de déployer tous les efforts possibles pour renforcer la capacité des États de mener au plan national des enquêtes sur les crimes commis à grande échelle et d'en poursuivre les auteurs. Excellencies, ladies and gentlemen, today we have paused for a brief moment to come together in this solemn gathering. But tomorrow morning we resume our judicial work, which is indeed going on in full force. While today marks the formal opening of the judicial year, the truth is that we have already taken a flying start since the beginning of January with hearings and deliberations in our cases. 3 trials are in progress and reparations proceedings are underway in 4 other cases following convictions. Indeed, reparations to victims as a new frontier of judicial activity was one of the topical issues of the past year. Several reparations decisions were issued in 2017, awarding both collective and individual reparations. Also, the appeals chamber is occupied with appeals related to reparations proceedings, and notably the appeals against the final conviction and sentences issued in 2 cases. These 2 judgments are expected in the coming months. The pretrial division is currently seized of a request by the prosecutor to open an investigation into a new situation, following another such request that was granted last year. Most colleagues are busy, sitting simultaneously in several chambers, for instance, hearing a trial in one case, while sitting in a pretrial chamber or dealing with reparations in another case. This is inevitable, taking into account that the number of judges remains 18, while the number of situations and cases before the court continues to grow. The expanding scope of our work underlines the importance of investing continuing efforts in improving the court's performance and efficiency. Much effort has been made by the judges of our court to this end, and much progress has been achieved in the last years. The judges have sought to improve and accelerate judicial proceedings through a collective assessment of the legal framework and methods of work. Among other efforts, 3 judicial retreats have been central to channel collegial discussions across chambers and divisions, allowing judges to revise entire phases of the judicial cycle, identify and harmonize best practices, and generate a number of initiatives to amend, where necessary, the legal framework, practices, and methods of work. The reforms we have put in place are already having a visible impact in our courtrooms and cases, including a clear and drastic reduction of the time required for some phases or aspects of proceedings. I remain convinced that respect and cooperation for justice efforts is linked to performance. We must constantly strive to improve our governance as well as the speed and quality of the justice that we deliver in order to enhance our credibility and foster support. 2018 will be an extremely important year for institutional developments at the court, as 6 newly elected judges will be sworn in March, replacing 6 of the current judges, including myself, in the bench. The new composition of judges will need to take important decisions for the governance of the institution, including the election of the new presidency and the election of the registrar for a 5-year term. Integrating new judges who come from different backgrounds, legal systems, and traditions every 3 years represents many challenges for the institution. While the regular injection of new energy and fresh ideas is necessary and highly welcome, we must at the same time strive to ensure sufficient legal predictability for parties and participants in the proceedings and safeguard reforms intended to increase efficiency. I am confident that efforts to consolidate a more cohesive judicial culture through a constructive dialogue will continue. Excellencies, ladies and gentlemen, the International Criminal Court was created on the belief that an international system cannot be associated with a particular legal system or a particular set of values. A truly international system incorporates elements of legal systems and traditions of the world and represents values that resonate across the globe. This premise continues to be valid today. There is no particular legal system that is per se more apt for investigating and prosecuting this type of crimes. We must strive to identify the best tools of each system in order to improve the quality of our work. We did it together at the ICC among all judges, and I believe this dialogue needs to extend to other courts and tribunals. Our judicial seminar held today is part of the efforts to engage in a necessary dialogue between national and international judges on how best to tackle our respective justice mandates. Excellencies, as we commence the new judicial year, I would like to take a moment to acknowledge all those who play a role in our proceedings, some of them visible in the courtroom, some of them behind the scenes. As in any court, the work of judges is assisted tremendously by the professionalism of the lawyers appearing before them. Indeed, the contributions of the Counsel for the Prosecution and Defense, as well as the Counsel for Victims, are essential for the quality of our proceedings. I would also like to acknowledge the indispensable services provided by the registry of the court. Without the assistance of interpreters, court management teams, security officers, audiovisual technicians, IT support, and many others, we would not be able to do our work. Last but not least, I would like to use this opportunity to recognize the contributions of all the individuals that make justice possible by accepting to appear before our court as witnesses. They deserve our respect, support, and admiration for their courage and invaluable support for justice efforts. Central to our justice efforts are the victims of crimes. They have the right to participate in proceedings, to express their views and concerns, and request reparations for the harm suffered. Following earlier convictions, this innovative feature of our legal framework is now being tested, and as I said earlier, proceedings on reparations are currently occupying much of our judicial docket. The vital role of the Trust Fund for Victims in this regard is also increasingly recognized. The participation and reparation of victims is essential for a system of justice that seeks to be restorative as well as retributive. Their access to international justice enhances its impact and increases ownership by affected societies. Excellencies, ladies and gentlemen, we are deeply honored that His Excellency Anthony Carmona, President of Trinidad and Tobago, accepted the invitation to be the distinguished guest speaker at today's ceremony. I could not possibly think of a more fitting person for that task. May I recall that Mr. Carmona is the president of the country that put the initiative for the creation of an international criminal court in the global agenda in 1989. This set in motion the negotiating process that would lead to the adoption of the Rome Statute in 1998. President Carmona is also a distinguished lawyer with extensive expertise in international criminal law. As such, he was elected as judge to our court in 2012, a position from which he resigned when he was elected to be head of state. To this date, Trinidad and Tobago has remained one of the court's strongest supporters, and we were grateful to hold a regional ICC seminar in Porto, Spain, almost exactly a year ago, with the personal participation of President Carmona, reflecting his deep personal commitment to this institution. He's a true friend of the court in every sense. We look forward to hearing his remarks after a musical intermezzo. I thank you for your attention.
Thank you very much, Madam President. Mr. Edmond Fokker van Crayestein will now perform two musical pieces for us. Mr. Fokker van Crayestein, I invite you into the courtroom.
Chance. Et après ça, c'était très, très, très léger, n'est-ce pas? Je voudrais jouer quelque chose en français, une pièce française. Pas en français, c'est pas possible. C'est Méditation de Massenet.
Thank you very much. It is my honor now to invite His Excellency, the President of Trinidad and Tobago, to take the floor.
International Criminal Court, Sylvia Fernandez de Gomendi, judges of the International Criminal Court, Madam Prosecutor, Mr. Deputy Prosecutor, Mr. Registrar, Mr. President of the ICC Bar Association, Your Excellency, Mr. President of the Assembly of State Parties, Honorable Chief Justices, Presidents and judges representing national, regional, and international jurisdictions, Excellencies, distinguished guests, ladies and gentlemen. In keeping with the fine traditions of the practice of law, many courts worldwide open each new law term with a ceremony of sobriety and solemnity that at the very least let its stakeholders know that the judicial, independent arm of the state shall do its just duty for another year. This is a beacon of hope that manifests itself sometimes in parades, sometimes religious services, and in today's case, by this remarkable singular initiative, interposing judicial education with ceremony. The opening of a law term, incorporating its stakeholders, the judges, defense attorneys, prosecutors, court personnel, and the public at large, is a strong visual statement of solidarity that we all are in the important business of justice for all. A celebration that recognizes 20 years of the founding treaty of the Rome Statute is well placed and well merited. To be your distinguished guest speaker at this landmark event in the ICC's rich 20-year-old history is indeed a humbling experience. My presence here today at the seat of the court of which I was a member is like a homecoming. I recall my tenure as a special advisor on criminal law to the late A.N.R. Robinson, former Prime Minister, and later President of the Republic of Trinidad and Tobago, at the preparatory conferences at the United Nations in New York. I recall many in the trenches of the genesis of that Rome Statute: Hans Corell, Professor Sheriff Basayuni, and of course the late President Robinson. President A.N.R. Robinson was a statesman who is universally recognized for his unrelenting advocacy and political work at the international level to reactivate what had become by 1989 a dormant idea for the establishment of a permanent international criminal court. President Robinson's work was the launchpad that eventually led to actions at the level of the United Nations General Assembly, the International Law Commission, and eventually the Rome Diplomatic Conference on the ICC, which led to the adoption of the Rome Statute of the ICC and the establishment of this court. As I stated at the high-level seminar for fostering cooperation with the International Criminal Court, hosted by the ICC in Port of Spain, Trinidad and Tobago, in January 2017, to those wavering souls, I say, stay in the ICC or come on board. There is nothing to fear, F-E-A-R, because the ICC is fear, F-A-I-R. There is an intractable benefit being party to the Rome Statute and acceding to the jurisdiction of the ICC. And this very opening ceremony allows us to take stock, to reaffirm our vigilance in defense of the rule of law and fundamental rights and freedom regimes in our individual countries. I dare say, vindication and acclamation for such hallowed principles have become grounded in the benchmark standards invoked by the ICC through its processes, procedures, and decisions. Let's be clear here. The International Criminal Court is the international guardian and guarantor of the rule of law. This inaugural opening ceremony of the ICC is a celebration of the past 20 years and an opportunity for the court to demystify its purpose, to account to its stakeholders, to evaluate its successes, and to prepare for the continuing challenges that lie ahead. One safeguard inter alia that always maintains the integrity of an institution is accountability. This was not lost upon your president, Judge Silvia Fernandez Gormendi, when delivering the ICC's annual report to the United Nations General Assembly in New York in October 2017. The Honorable President stated, the concept of, and I quote, the concept of accountability has been firmly put in the global agenda. The emergence of this principle as a norm under international law has changed the parameters for the pursuit of peace. There is now an expectation that there will be accountability for the most serious crimes and the conviction that is necessary for sustainable peace. The question is no longer whether to pursue justice, but rather when and how, end of quote. Today, as the ICC commemorates the milestones of an inauguration and an opening ceremony, the resonating themes implicit in the court's very existence are accountability, transparency, independence, cooperation among member states, nation states, and the universality of the Rome Statute. With these aspirations, the ICC will have attained the status of full recognition, acceptance, and compliance by nation states of the indispensable role that the court plays in bringing to justice the perpetrators of genocide, crimes against humanity, war crimes, and I'm pleased to add the crime of aggression. The decision adopted by consensus at the recently concluded session of the Association of State Parties in December 2017, held at the UN headquarters in New York, on the activation of the jurisdiction of the court over the crime of aggression, as well as on amendments to Article 8 of the Rome Statute, agreed upon in Kampala, Uganda in 2010, long overdue, is welcomed and well-merited. It signals affirmatives on many fronts, most pivotally for the victims of crimes of aggression, as well is a success story for the ICC, as it builds bridges and alliances with other international organizations, such as the very United Nations. The crime of aggression must have its moment, strange thing to say, especially when it had bloodied much of history's timeline with acts so heinous that they desecrated and defiled the sovereignty of states and the dignity of their citizens. In telling measure, demonstrating man's inhumanity to man. Indeed, this moment in many ways belongs to the victims who shall receive their due justice before this International Criminal Court, hopefully in short order. The activation of the ICC's jurisdiction over the crime of aggression has filled that residual gap from the diplomatic conference in Rome in 1998, which could not agree on the definition of the crime nor on the conditions for the court's exercise of jurisdiction. With this superintendence of the ICC's jurisdiction, those accused of the commission of the crime of aggression would be brought to justice under Article 25 of the Rome Statute and shall be held, and I quote, individually responsible and liable for punishment. And most importantly, would not be able to use defenses such as official capacity or superior orders to escape justice. Ladies and gentlemen, this is a good day to re-emphasize the supremacy of the rule of law in times still gravely tormented by dictatorship that exists in and out of military camps. In fact, even on Twitter, in a war of words, of threats, in attempted displays of power and chauvinistic dominance, where nuclear bombs are the bait. But that is a story for another day, another time. A passant, this saber rattling does not lend itself to a reliable and sustainable international peace, law, and order. Another significant development emerging from the activation of the crime of aggression may well be that this historic session of the ASP took place at the United Nations headquarters in New York. The optics of this cooperation and collaboration hold as much value as the strength of union between the UN and the ICC. Indeed, the drafters of the Rome Statute recognize that while the ICC's mandate is to prosecute the most serious crimes to the international community, its purpose is also to act as a deterrent to the commission of those international crimes. Correspondingly, this court does not exist in isolation, but is part of the global architecture committed to the maintenance of international peace, law, and order. It is for this reason the preamble of the Rome Statute of the ICC affirms the purposes and principles of the Charter of the United Nations and contemplates a symbiotic relationship between the ICC and the UN. The relationship agreement between the ICC and the UN gives effect to the provisions of Article 2 of the Rome Statute. Excellencies, ladies and gentlemen, cooperation is central in order for the ICC to fully realize the diktat conferred on it by all people of conscience that are responsible for the creation of the ICC, and more so, for those who subsequently embraced its mandate, as well as those states that would in the future accept its jurisdiction. In this vein, I salute the ASP for adopting a resolution on cooperation in its last session. In the same breath, I also commend those state parties which have withdrawn their notifications, hopefully permanently, to denounce pursuant to Article 127 of the treaty. It is my fervent hope that progressive actions would serve to cause a flow of additional accessions to the Rome Statute, which are essential to achieve universalization of the court, thereby making the system of criminal justice a truly global one. Our goal should be the achievement of 193 state parties to the state statute to reflect the entire membership of the UN General Assembly. In some measure, the operationalization of the ICC have been stymied at times by a cooperation from certain countries that is transient, convenient, occasional, and in the extreme non-existent. The iniquity of non-cooperation by nation states often opens the doors to unfair and unjustifiable criticism of the ICC being ineffective, ineffectual, and non-productive. Cooperation, ladies and gentlemen, among member states and even organizations can be challenging. I recall, Madam President, in your annual report to the UN General Assembly on October 30th, 2017, you further expressed, and I quote, grave concern that requests for arrest or transfer remain outstanding for 15 individuals, end of quote, and called on the Security Council to take measures with respect to the situations in Libya and Darfur to ensure full cooperation with the court. You surmised that the failure to do so could help to perpetuate impunity, as those accused of perpetrating grave crimes will fall within the ICC's jurisdiction and that they can go unpunished. No doubt, if this development is allowed to continue, it will only serve to reduce the efficacy, utility, and productivity of the ICC, as cooperation on the part of the UN, state parties, and other states is essential in order for the court to fully discharge its mandate and functions. Remember, at the heart of the successful prosecution of Jean-Pierre Bemba Gambo was cooperation and coordination by several nation states. Such cooperation is not at variance with a system of interdependence so indispensable to the ICC's success. It is my expectation that all state parties must examine their legislative agenda to determine whether same gives full effect to the operational provisions of the Rome Statute, detailed in Part 9 of the instrument. The legislation of nation states must be so enabling as to fulfill the various cooperation requests contemplated by the Rome Statute. And implementing legislation must be able to address particular requests such as the arrest and transfer of suspects, freezing assets, protection of victims and witnesses, and sourcing evidence. The International Criminal Court, lacks direct enforcement powers. And this situational circumstance requires the cooperation of all states to effectively investigate and prosecute perpetrators of international crime. It was indeed a progressive step when on the 15th of December 2017, the new president of the ASP, Mr. Jajogon Kwan of the Republic of Korea, met with the president of the General Assembly of the UN, Mr. Miroslav Lajcak, and UN Secretary General, Mr. Antonio Guterres, where, and I quote, reference was made to the important role of the United Nations in supporting the Rome Statute system, including by facilitating the holding of sessions of the ASP to the Rome Statute at the UN headquarters, end of quote. It was further reported, and I quote, that during the meetings, discussions centered on the role which the International Criminal Court plays in the system of international criminal justice, on the importance of seeking to advance the universality of the Rome Statute, on the continued need for diplomatic support to the court, as well as the need to strengthen cooperation with the court, end of quote. The UN and the ICC will continue to benefit from a solid, respectful relationship with each other, since they share common goals and values, and the court is often engaged in situations that are of concern to the very UN. It holds to reason, then, that continued efforts must therefore be made to sustain and augment the burgeoning relationship that exists between the ICC and the UN. As I stated at the Port of Spain High-Level Seminar in 2017, more mediative dialogue and open and frank discussions are needed among the court, member states, regional and international stakeholders, such as the UN Security Council. And as I stated, the International Criminal Court was created from the bowels of a diplomatic process. And in that regard, it makes sense to engage in similar diplomacy in acknowledging and addressing inter alia the principled, consistent, and just approach to UCC referrals by the UN Security Council. From inception, the ICC as an institution has had to persevere facing multifaceted obstacles. There have been criticisms and at times misplaced allegations about the performance of the court, or rather, its perceived lack of performance. It has not been an easy road for the ICC, and I am comforted by the fact that despite all the attempts to undermine and dismantle, the court has not shifted from its moorings and has not compromised or violated the object and purpose bestowed on it by its founding treaty. An imperative that must be pursued with the required vigor is for state parties to accede to the agreement on the privileges and immunities of the ICC, so that when the personnel, including judges of the court, are conducting the business of the court, they must be able to do so in an environment that assures total independence. Judges and the personnel of the ICC must be allowed by a state party to work freely and unencumbered in an environment that is not intimidating through sometimes intentional breaches of privileges and protocol. Judges, I urge you to remain steadfast, remain vigilant, and continue to ensure that you adhere fully to the tenets of Article 40 of the Rome Statute on the independence of your hallowed positions as judges. Yes, I am aware that there may be issues of funding when, for example, requests for investigations are made. But at no point must economics influence or trump the efficiency and independence of any office, including the International Criminal Court. There cannot be any half-hearted approach to judicial independence. I say this only to emphasize, because I'm preaching to the choir, that as judges, you represent an honorable judicial system, as I've stated, which is the international guardian and guarantor of the rule of law. It may well appear self-serving, but my Caribbean and CARICOM region have always been committed to international benchmark standards and practices with a strict adherence and respect for fundamental human rights and freedoms and the rule of law. I wish to emphasize that in the Caribbean region, We represent a cohesive force with an unstinting support for the mandate, agenda, and the existence of the ICC. We must never lose our sense of purpose and direction in supporting the ICC. The Venerable Benjamin Ferencz, the only living former prosecutor at the Nuremberg tribunal, whom I had the pleasure of meeting some years ago, gave an account of the evidence leading up to his case to the United Kingdom Guardian newspaper in 2017 to mark the 70th anniversary of the trials of the Nazi criminals at Nuremberg. 97-year-old Mr. Ferencz recalls with a memory that defies his years. And I quote, "There were 3,000 men who for 2 years murdered people, including children and infants, one shot at a time, or as one of my lead defendants who killed 90,000 instructed his troops. If the mother is holding an infant to her breast, don't shoot the mother. Shoot the infant because the bullet will go through both of them and you will save ammunition." End of quote. In describing his experience in visits to the concentration camps, Mr. Ferencz went on to say, and I quote, "It was an experience indescribable because of its horror. It was as if I had peered into hell, and that's why I am still fighting to prevent that from happening again." And if in fact Mr. Ferencz, at the age of 97, can express with such rigor this undying philosophy to ensure that hell no longer exists on this earth through the diverse actions of those persons responsible for those actions. Certainly, in fact, ladies and gentlemen, this can be our daily inspiration in the conduct of our affairs. My dear judges, this grand old man, this veritable sage, this epitome of what is good of humanity, lamenting about horrific events which took place over 7 decades ago that shook the conscience of those who believed in the sanctity of human life. Tragically, in our lifetime, we have been witness to similar atrocious acts in almost every continent of the globe after 1945. Therefore, as judges, you must see yourselves as gatekeepers of international human rights law and international humanitarian law, as codified in the Rome Statute and other relevant instruments. Remember, judges, your successful work enables the international community to have faith in the promotion and preservation of peace and the rule of law. Ladies and gentlemen, the basic premise of international human rights is that human beings have rights, based on the inherent dignity acknowledged universally, that we be accorded such rights based on nothing more than the fact of our humanity. The end product of this premise is that the individual is not defined by national law, nor are the dignity and respect to be accorded to an individual as a result of the administrative functions of an individual state. The International Human Rights Treaty is therefore the document that records the acceptance of these principles based on the above premise. It does not create it. Accordingly, the international norms that accept genocide and crimes against humanity as criminal conduct, which transcend national borders, are reflections of the deep-seated need for mankind to rise above the once prevalent notion that human beings that live in a particular geographic region, defined by recognized borders, are not necessarily subject to despotic rule. While respecting domestic independence, sovereignty can never be used again as a cover for repressive acts of cruelty against groups, whether a minority or otherwise. The appalling experience of war in the past and the use of media or its absence as a cover for the imposition of acts of cruelty and violence to impose the sovereign domestic and political will on human beings within the borders of a particular state are no longer tolerated as the right of a sovereign state. This is a basic tenet of the International Court of Justice. However, if my basic assumption is correct, then the existence of the court and its work in securing the prosecution of international crimes can never be enough. The court does not exist in a vacuum. It is part of an international movement that proclaims and encourages solidarity in working for the development of international justice. This cannot be defeated by the concept of sovereignty, because as we become more civilized, our experience as human beings informs us that common values and norms are the glue that preserve and encourages order and development along the principles of human rights. This need for a sense of justice finds its way into the development of international tribunals that adjudicate on international trade, international investment, international treaties, the use of the sea and the seabed, among others. Accordingly, we cannot escape the reality that slowly but surely there is an inevitable trend and journey towards judicial globalization. And how can this develop without affecting the core doctrine of sovereignty? I suggest that the first step must be the development of a type of international broad common law, where the judicial decisions and trends on particular subject areas are accepted as highly persuasive by other international tribunals, which will be slow to depart from those principles. There has to be set out the ground rules for such acceptance and also the ground rules for departure. The decisions and principles should be manifested in the written decisions of the courts. More so, this principle should be reflected where international tribunals are dealing with the same subject matter, although established by different treaties. International human rights principles, for example, cannot be treated differently by the ICC, the ICTY, the ICTR, or the European Court of Human Rights. With the winding up of operations of the ICTR and ICTY and other ad hoc tribunals, judges, you must demonstrate to the world through your balanced, fair, independent, and impartial judgments that there is no need for the establishment of any other mechanism, whether ad hoc or otherwise, that are complementary to national criminal jurisdictions with jurisdiction over the most serious crimes of concern to the international community. At the same time, although there are no hierarchy of courts at the international level, and some would also argue that there is fragmentation in international law, I humbly ask that you avail yourselves of the judgments, judicial reasoning which led to the decisions handed down in cases presided over by your brother and sister judges at the now defunct ad hoc tribunals. In order to achieve this type of judicial comity and continuity, relationships must therefore be encouraged between both national and international courts. I would go further to suggest that the ICC should promote the development and incorporation of seemingly constitutional principles that engage the consistent interpretation of rights between national and international obligations, and which inevitably remove the need for domestic incorporation on human rights treaties. The process is currently sporadic, at best. I can recall the South African court in the case of the state versus McAnwain, citing the European Court of Human Rights in support of its finding the death penalty to be unconstitutional. In Pratt & Morgan versus the Attorney General, the British Privy Council relied on the European Court ECHR decision in soaring on the UK, as well as a decision of the Human Rights Committee to commute a death penalty recipient in Jamaica to life imprisonment. The Inter-American Court has also relied on decisions of the ECHR and the UN Human Rights Committee. We can thus see the national courts have begun the process. These decisions acknowledge that national courts derive assistance from international tribunals, and they must stand ready to so apply and to so link to the juridical decisions of the ICC. The question is, do international tribunals derive assistance from each other? And if so, how might such assistance be manifested? The ratification of international treaties on human rights by nation states is evidence of the acceptance of the premise with which I stated, and that is the supremacy of human rights in any system of laws. It seems to me that the international human rights treaties ought to be treated as an exception to the rule in dualist countries that human rights treaties have to be domestically incorporated in order for the human beings within the sovereign state to receive the accorded protection. The protection is granted to human beings, not citizens. As I've stated previously, the universal commonality of standards by the international community enforces and fosters the rule of law. Sovereignty, therefore, cannot and must not be invoked on the altar of impunity. In order to achieve this objective, judicial contact has to be encouraged between national and international judges on a consistent basis. National judges ought to be exposed to training in cross-border international norms that will begin the process of familiarity, which is the genesis of comity. There must be a community of judges that is part of a global community of judicial officers. This inaugural opening ceremony and seminars hosted by the ICC, such as the one in 2017 in Port of Spain, in Costa Rica, in Botswana and Romania, are valuable opportunities for judges at the domestic level and at the international level to connect, share, and learn from each other in an attempt to bridge gaps. I cannot help but emphasize the importance of seminars, workshops, and fora taking place not only in member states of the ICC, but also in those marginal states that harbor wavering doubt about the utility of the ICC in the context of international justice. I am not talking about talk shops, but rather a dialogue that crystallizes pellucidly clear the transformational ideas of an international justice system done in such a way that it targets not only the proverbial man at ground zero, but very importantly, the relay runners of tomorrow, our young men and women. It is imperative that when such fora are taking place, that they are not restricted to the policymakers who walk the corridors of power. These seminars must incorporate secondary, university, and other young people, which will not only set the stage for continuity of the good work of the ICC, but will serve as a strong measure of connectivity to the valid ideas our young people need. Indeed, earlier today, the judicial seminar organized by the ICC theme Complementarity and Cooperation of Courts in an International Global and Justice System promotes the vibrant interconnection of national, regional, and international courts as part of a judicial global system. We must also, I suggest, accept that there is a need to educate the man in the street about the role and function of the international criminal justice. Unfortunately, because the genesis of the court has always been out of wars and atrocities committed during the course of a war, the court is perceived as being successful only when there is a conviction. The process is not perceived to be as important as the result. This perception that a conviction is an indication that the court is doing its work and that of an acquittal, the reverse is true, must be disbanded. The work of this court is the pursuit and attainment of justice, not convictions. There is no such thing as an endemic right to a guilty verdict. The endemic right lies to a just verdict. In all of the above, the key element is dialogue. Dialogue at national levels, transnational levels, and diplomatic levels. The dialogue must be between individual judges in their different capacities. In a sense, the cooperation and development must be horizontal between international courts and vertical between national and international courts. And of course, as I previously mentioned, with all relevant regional and international stakeholders. The International Criminal Court continues to demonstrate that despite all of its detractors, it continues to persevere to carry out its mandate under the Rome Statute, which also includes allowing for the participation of victims in the proceedings and the ordering of reparations to victims, as was done in the Lubanga and Kantanga cases. As your President, Judge Sylvia Fernandez de Gourmendi, remarked not so long ago, and I quote, "Central to the justice efforts at our court are the victims of crimes. They have the right to participate in proceedings to express their views and concerns and request reparations for the harm suffered. The participation and reparation of victims is essential for a system of justice that seeks to be restorative as well as retributive," end of quote. As in any system of criminal justice, reparations to victims will always have an important role, and we must always look at the glass half full. While monetary compensation may be the ideal form of reparation in some cases, in many others, return of property, rehabilitation, infrastructural developments to improve affected communities, hospitals, student scholarships, for education is the key that opens all doors. Or symbolic measures such as apologies or memorials may mean more to victims of particularly traumatizing and heinous crimes than any amount of money can ever compensate. I cannot help but laud the appointment of a former colleague of mine at the ICTY, Ms. Patricia V. Sellers, a special advisor on gender. Madam Prosecutor, Ms. Fatou Bensouda, has recognized the importance of gender sensitivity and gender vulnerability in prosecutions coming out of internecine and international conflicts. Ms. Bensouda stated, and I quote, "Since the adoption of our policy on sexual and gender-based crimes in 2014, the Office of the Prosecutor has been involved in various implementation initiatives, further integrating a gender perspective into all areas of our work," end of quote. As President, I have invoked a similar philosophy that has resulted in greater women and youth upliftment and empowerment, because I recognize the importance of genuine inclusivity in the progress of a nation. Madam President, I have also observed the increased workload of the court. I commend you on the number of important reforms being undertaken to enhance the speed and quality of judicial proceedings. Your new permanent premises, which were opened in April 2017, is befitting the status of the ICC as the only permanent international criminal tribunal, and it is a tribute to the ongoing contribution of the court to ensure, through the judicial dispensation, a safer, more secure world grounded in justice, law, and order. Indeed, there are times when, as a court, you may have to let someone go who is guilty on paper, but innocent on the basis of the evidence proffered. It is what justice is all about. It is a fortifying feature of justice when a court acts on evidence and evidence alone, not passion, public perception, opinion, or pressure. In other words, ladies and gentlemen, the court of public opinion is not a court of law. The court of public opinion may be a social barometer that tests the tenacity of a court's judgment, but it does not represent the law. The adjudication of matters and issues fall within the juridical dispensation of judges who have been elected as persons of integrity, independence, probity, impartiality, and competence in accordance with the Code of Judicial Ethics of the ICC. So if you have to make a decision, you stand firm and you make your decision. Because remember, as I've said time and time again, that the court of public opinion is not a court of law. The world today is in need of transformative leadership, governance, and equality of treatment. The ICC must therefore aspire to be that beacon, that bearer of good news to all who are victims of grave injustice at the hands of hegemons and self-serving, self-centered leaders who cling to the clutches of power by trampling on the inalienable human rights of ordinary citizens. I affirm the adage that there is no peace without development, and no development without peace. I however, also assert As has been stated before, there is no peace without justice, and no justice without peace. Finally, Excellencies, ladies and gentlemen, I urge you that in all things that you do, in and out of these hallowed halls of justice, in dispensing justice, in adjudicating on matters, stand firm, stand strong, and do the right thing, because it is the right thing to do. Thank you very much, ladies and gentlemen.
Merci, Monsieur le Président. Pour la dernière partie de la cérémonie, je donne la parole à Madame la Présidente Fernandez de Grumen.
Excellencies, ladies and gentlemen, on behalf of my colleagues, I thank His Excellency President Carmona for his great, inspiring remarks. I thank all of you for your presence with us today, and I declare the judicial year of the International Criminal Court opened.
This concludes the official ceremony. You are kindly invited for drinks, and protocol staff will assist to proceed to the lobby of the court.